All right, guys. Hello, my name is Rob Chestnut. Thank you for joining us for this Facebook Live. It's my first time doing something like this, so I will try and make it as entertaining as possible as we're going through all kind of this dry stuff, having to deal with DWIs. Thank you very much for Texas Legal for putting this on. I imagine many of you are already members of Texas Legal. If you're not, definitely check it out. It's a really good program to get your legal fees, all your legal fees paid for. It's a really good thing. So I'm just going to kind of jump right in. I'm an attorney based in Austin, Texas. Do mostly criminal defense. So, you know, we end up on all those top 10 lists of drunkest cities in the United States. So there are a lot of DWIs here. And so it does end up being a pretty big chunk of my business. And it's also one of those types of crimes. The saying is, but for the grace of God go I. Most people who are intoxicated have at one point in their life gotten behind a wheel. I know I have. Fortunately, I've never been arrested. I don't do that kind of thing anymore. When I was younger, made some decisions that I don't make anymore. But anyway, just for the scope of this, I'm not really going to talk about dealing with the police in a DWI stop. I'm kind of going to take the tact of once you've been charged with the DWI, how do you handle it from there going forward? There are plenty of videos about dealing with the police, and I would check YouTube for some entertaining ones on that. But so the typical situation is you get arrested, you spend one night in jail, and usually you get a personal recognizance bond or a small bond that you can pay, usually like $100, depending on the county. You know, I'll touch real quickly before I move forward on that. Every county is different. So a lot of the things I'm saying are generalizations. They apply in Travis County, and a lot of times they apply across counties. But every county has little quirks. So it might not be exactly the same, but it will be something similar. So usually you only spend one night in jail. If you're in custody longer than that, it's because it's usually a more severe case, usually a felony DWI. We're not really talking about felony DWIs either. We're kind of keeping it focused on misdemeanors because felonies really are a completely different animal. So, you know, if you aren't released immediately or the next day, obviously get in touch with an attorney for a jail release. That's going to be the first concern. But usually people are going to be released the next day. I'm going to kind of skip driver's license issues, and then if there's time, we'll talk about that at the end. But they will confiscate your driver's license, but that doesn't mean your driver's license is suspended. You need to request an administrative license revocation hearing, an ALR hearing. That's going to at least put a temporary hold on getting your license suspended. And you can do that online, or your attorney can do it for you, but you have to do it within 15 days. So, you know, jump on that. But we'll go more into driver's license later if there's time. So what you'll get usually is a PR bond. It's some paperwork that's showing that you're being released. It'll have a court date on it. You know, a lot of people get real anxious and they look at that court date. They don't know what it's going to be like. You know, some people think, is that going to be a trial? You know, it's not a trial. Usually that first court date is just to get you an attorney. So if you do have an attorney, most jurisdictions, either the attorney can handle that first setting for you, or get it reset and you won't even need to go. So, you know, one of the best things I think that an attorney is going to do for you is sort of relieve that anxiety and kind of give you a bit of a roadmap for what's going to happen. So when you show up to court, you're not expecting a full-on trial with the jury. You know what's going to happen, that it's just going to be reset, or, you know, whatever is going to happen that day. But just to give you an idea of timeline, those trials never happen at that first setting. Usually, if there is a trial in a case, it happens about a year or more, you know, especially with COVID. Those trials are going to be happening a year or more out. So, you know, some people think that the timeline, you know, they think swift justice, but it doesn't really exist unless you have different definitions of swift than I do. But yeah, you don't have to have that anxiety if you have an attorney to handle those for you. So sometimes the bond will have conditions. You know, for a DWI, the most common condition is going to be the ignition interlock device. It's not going to be in every bond. You don't automatically have to go get it. The judge actually has to put that condition on the bond. But if that is a condition of the bond, you have to go and get that installed within a time frame, usually about a week from the time you're released. And you go through a private vendor through one called Smart Start. And those are a pain. There's no way around it. Ignition interlocks are a pain in the ass. Sorry, I shouldn't use those words. Sorry about that. Texas Legal. But you know, and a lot of people think, you know, I'm innocent until proven guilty. How are they punishing me when they haven't proven anything? Well, these conditions are really just for technically for the safety of the community. They're not technically a punishment, even if they feel like a punishment. So a judge can impose any condition for the safety of the community, and the IID is one of them. Now, usually, if you can keep a clean IID, meaning you don't have any violations where you blow over a certain BAC, blood alcohol content, we can get that removed usually within 45 to 90 days, depending on the judge. Some judges won't remove them, really depends, but most of them are going to give you credit for when you do keep it clean for a certain amount of time and show that you can do that, we can get those removed. Another thing that might be a condition is that they might ask you to go to counseling and classes. Usually the classes are a 15-hour class, but in Travis County, they can go up to 35 hours for more severe DWIs, and a MAD victim impact panel, which is a couple hours. But by far the most annoying condition that's gonna cause you the most pain will be that ignition interlock device. And it's pretty expensive. I mean, it costs, I think, $95 to install it, and then it's something like $55 or $60 a month to keep it going. And you have to also physically go to Smart Start or whatever vendor you choose, and have it calibrated where they look for violations. So it becomes a big pain in your life. But hopefully, you know, in most cases, you can get those taken off after a certain time. So the first step that once I'm hired as your attorney, what I do is let the court know that, you know, I'll be handling the case, and then I request discovery from the prosecutor. Discovery consists of all the evidence that the prosecutor is going to give you, and it's the evidence that they would use at trial, if there was a trial, to secure a conviction. And Texas has followed suit with all other states, and now they kind of have this the prosecutors don't technically have to give you everything, but they basically give you everything. So what I get is usually an offense report, a video, and that can be dash cam video, or a lot of times now body cam, any kind of blood alcohol test, whether that's a breath test or a blood, any kind of 911 calls if there was someone saying, you know, this person's acting crazy, driving crazy, and criminal history. So if you have prior DWIs, I'll be able to see that in the criminal history. And there's you know, other types of evidence you can get, but those are the main ones. And once we get all that evidence together, it gives me a pretty clear idea as to what kind of case we're dealing with. Is this going to be a really tough case, or one that we can maybe get a really good outcome, maybe a dismissal or a refile as a Class C? And we'll talk about what those good outcomes are later on. But generally, when I'm looking at a case, there are 5 different factors that I'm looking at. And these are just general guidelines. It's certainly not comprehensive, and in no particular order. But these are the things that can make a case more difficult for the attorney as opposed to less difficult. So the first is criminal history. So if this is a second DWI, it gets bumped to a Class A misdemeanor. But more than that, the prosecutors are going to say, okay, hold on, this is a pattern now. And it does make a difference whether this previous DWI was last year or whether it was 10 years ago. It still bumps it up to a Class A either way, but the prosecutor might look at those two situations very differently. Second factor is whether there was an accident or an injury. That's definitely going to bump up the severity. If there's a severe injury, it could be intoxication assault, which is charged as a felony. And if, you know, that even bumps up to, you know, homicide, vehicular homicide, which obviously is a different ballgame. But if there's even a fender bender or even a single car accident where you've run into a pole or a tree, it is seen as a more severe DWI by the prosecutor. Third is going to be BAC level. If there is a blood test or breath test, if that's way over 0.08 or way over, if it goes over 0.08, it is per se DWI. If it goes over 0.15, it gets bumped up to a Class A misdemeanor. But some people confuse that and think if it's not above 0.08, then it can't be a DWI, but it actually can. Those cases are definitely easier to deal with, though. So if the BAC, let's say we get a blood back and it comes back as a 0.05, it's below the 0.08, well, a lot of times that's going to end up in a dismissal. Not always, but most of the time we can usually work those cases out. The next factor is just going to be, it's kind of a intangible one, but just the general appearance of the driving. So if the officer is pulling someone over and they're swerving on and that's on camera, that's not going to be a good thing. But if they're seem to be obeying traffic laws, seem to be driving well, that's going to be a point for you. And lastly, it's just the general behavior of the person when they're stopped. Are they slurring their words? Are they stumbling? How do they do in the field sobriety tests? If they refuse the field sobriety test, you're still looking at that behavior. And that's going to be a big factor. And you know, that's just, if you think about it, you know, if you imagine yourself being on a jury, what kind of things would make you think that someone is intoxicated? And those are going to be the things that can make a case better or worse, depending on how the person looks. And it's very intangible. It's not something that there's like a clear answer. This one's really bad, this one's not. It's more of a spectrum. So moving on, there are a few issues that we can handle pre-trial, and this is talking about trying to get the case thrown out. So this doesn't have to do necessarily with how intoxicated you were. You have to show that the prosecutor has to show that they had probable cause at each step in the investigation, and it is helpful to break it down into steps. So they have to first have probable cause that for that initial stop. And usually that's going to be you know, a minor traffic violation. The term for it is pretextual stop, meaning they had a pretext to pull you over. And courts have found that to be okay, even if the officer admitted, yeah, I'm pretty sure he was drunk, but we didn't have probable cause for that. But I saw he had a broken taillight, so I pulled him over for that. He can admit that on the stand, and it's completely fine. Courts have said that's okay. So that's probable cause for the initial stop. And if they don't have that, you throw the whole case out. It's done. The next step is going to be probable cause actually for the DWI investigation. Excuse me. So it's not enough just to have that broken taillight. They have to have some reason to begin investigating for the DWI. Usually that's going to be something like, I detected the strong odor of alcohol when I opened the car door. Okay. We can't really challenge that. And that's one that they put in basically every offense report. So I don't know if they're just have, you know, a really good sense of smell, or if yeah, I'm sure some of them there really is that odor. I don't deny that, but it's just an easy one for the officer to put down to get that probable cause. Third, they have to have probable cause to take the blood or breath test. And if you can challenge that, you can sometimes get the blood or breath thrown out. That doesn't necessarily lead to the entire case being thrown out, but it definitely strengthens your case. And then lastly, they have to have probable cause for the arrest. But once they have probable cause for that other stuff, they usually have it for the arrest as well. And then there are also ways to get the blood and breath thrown out. There are a long list of things that the phlebotomist has to do to follow procedures. And if they don't follow those procedures, you can challenge them. And those blood draws are videoed. So you can, you know, there is a check, at least in Travis County. That's not true in all jurisdictions, but in Travis County, we get a video of the blood draw, and we can make sure that everything was done correctly. And if it's not, the blood can get thrown out that way, and that can really strengthen your case. Same goes with field sobriety tests, although usually if the field sobriety test, and what I'm talking about there, let me clarify, it's usually 3 tests. It's the walk and turn, the one-legged stand, and then the nystagmus tests, where they take the pen and do that. And with that, they're just looking for a jerkiness in your eyes. It's an involuntary thing. It's not whether you can follow the pen. But if they don't do those correctly, that's usually not a basis to get the whole case thrown out. But it is something you can bring up in front of a jury, and that can help your case. And you can talk about it with the prosecutor in negotiations. And that's one thing I do want to mention is, you know, I'm kind of referring to all this as it relates to jury trials. A lot of people don't realize that while the whole case is going, we can be negotiating with the prosecutor. That can be up until a jury is picked, or even after a jury is picked. And so all of these factors, even though they go towards jury trials, they also go towards the strength or weakness for the case as it relates to negotiating with the prosecutor. As 95% of these cases end up in pleas, a lot of times, the person we're really trying to sway is the prosecutor, unless they're just totally not listening to logic, and then it has to go to trial. But 9 times out of 10, what makes these things work is that, if we can show that we're poking holes, if we're like throwing the blood or breath out, then the prosecutor is going to realize their case isn't as good. Now they're going to come down to an offer that is more palatable and one that we want to take to avoid a trial. So usually during these, how do we decide if we're attacking the case or if we're kind of playing ball and being real sweethearts with the prosecutors? Usually I'm doing both, right? So I'm going to be looking for reasons that their case is weak and setting it on a pretrial hearing. But I'm also going to be, while this is happening, calling up the prosecutor and saying, hey, my guy's already completed his classes. He's completed the MAD panel. He's doing what he can. He's kept his IID clean. What kind of offer? This guy just made a one-time mistake. What kind of offer can you give us? And a lot of times using those two things in tandem is going to get you the best offer, as opposed to, I'm not ever that attorney you see on TV that is, coming in with, surprise evidence and, catching everybody with their pants down. That works on TV, but it doesn't work as well consistently over time, case after case. Usually, I want to have a good relationship with the prosecutors. And, if I'm setting it on a hearing, they understand that, yeah, I'm setting it on the hearing because there is a potential problem with the case. And another reason, just to circle back to the hearings, another reason to do that is as long as there was no warrant for the arrest, which there never is for a DWI case, it's always someone just pulling someone over. The prosecutors have the responsibility to bring the witness, the police officer. So if they don't bring the police officer, they have to continue the hearing. If they continue the hearing enough times, the judge is going to not allow them to continue it, and they're going to throw the case out. So that's another way that we can put pressure on the prosecutor to prove their case pre-trial without having to set it on a trial date. And that can, even if it's not thrown out, a lot of times the prosecutor is going to say, okay, well, our officer didn't make it last time. What kind of offer do you want? Let's talk about this, and we get that better offer. And so that's going to bring me to kind of the outcomes, so kind of the end result of why we're doing this. So what are the best outcomes in DWI cases? And I'm going to do this from best to worst. So, and again, I'm only talking about misdemeanor cases. We're not really going to be going into felonies. With misdemeanor cases, jail time is actually very, very rare. It's not unheard of, but it's kind of reserved for very, very serious cases. Most of the time, probation is going to be the result, or something like that, if you have a penalty. So the actual best outcome you can get, obviously, is dismissal, right? And this does happen. If there's a bad case, or if it's just a not very severe case, let's say the officer thought someone was drunk, but then that BAC comes back 0.05, prosecutors aren't really going to want to take that to trial. They know that, we know that, and so sometimes they'll just dismiss it. And that's obviously the best result. It's pretty rare, but it does happen sometimes. So the second best outcome will be a refile to a Class C misdemeanor. Class C misdemeanor is like a traffic ticket. That'll be also for especially weak cases. It does happen actually quite a bit. And lately with COVID, so this is actually, if I'm talking to someone right now that has a case, right now is the absolute best time to go negotiate something with a prosecutor, because they have so many cases backloaded from COVID. They are giving some of the best deals that I've seen. So I actually got a Class C refile a couple weeks ago on a case that maybe wouldn't have in other situations. So like I said, this is June 10th. If you have a case right now, go see what you can get before the courts open back up. So if you can't get a Class C refile, the next best thing in Travis County is pretrial diversion. Now, this is going to vary greatly across jurisdictions. And in fact, pretrial diversion in Travis County was not very good up until last year when the program changed, because even the great thing about pretrial diversion is it does lead to a dismissal. You can get your case expunged, but there are some hoops that you have to jump through. So in Travis County, you do have to have an ignition interlock for 12 full months. So that's not fun. But when you can get your case dismissed, sometimes it's worth it. And in fact, a lot of times it's worth it. But these pretrial diversions can vary. The conditions and the hoops that they put on you that you have to follow to get the dismissal is very different from jurisdiction to jurisdiction. So just make sure before you just real quickly do a pretrial diversion, because Rob said it was a great result, just make sure that you've looked at what the conditions really are. For example, in Williamson County, it's not too bad, but then they require that you waive the expunction. So if getting it expunged is something that's very important to you, you would not be able to do that in Williamson County, but you can in Travis. So short answer is it's really a really good program. Long answer is just make sure that it is in whatever jurisdiction that you got your DWI. Next best outcome would be a refile to obstructing a roadway. So this is a legal fiction. It's not like you actually obstructed a roadway. You know, you pulled over when the police pulled you over. But what it is it's a way to get it. It's still a Class B misdemeanor, so it's above a traffic ticket. But it is a way for you to not have a DWI. It doesn't count as a DWI conviction. The penalties are usually lower, and it's usually a deferred adjudication or probation with less conditions than a DWI would have. And then the worst case scenario is you're getting a conviction. So that would be a Class B conviction with a max of 6 months in jail. Again, jail time not usually part of this, but it can be. And then a Class A with a maximum jail time of 1 year. There are fines. So recently, the legislature got rid of the surcharges program, which is great because there used to be automatic surcharges that would just be thrown into your account, and you'd have to start paying those or fine. But there were all these loopholes that you could get to not pay, and it was a big mess. Now it's a mandatory fine for final convictions, which makes it sound like you're paying these huge fines, which are $3,000 for a Class B, $4,500 for a Class A, and $6,000 if your BAC is shown to be above 0.15. So very hefty fines, but the way courts have interpreted final conviction is these only happen if either A, you take a jail time conviction, or B, if you take probation, but then get your probation revoked. And then you're going to be paying the fine, and there's no way for a judge to really not assess that fine because it is mandatory. It says the judge shall issue that fine. But that ends up happening in a very small percentage of cases, actually. I used to have clients that didn't want to go through a year or two of probation, and they would take a jail sentence. It will affect that situation because you could do a jail sentence over a weekend and not have to do probation for 2 years. And a lot of people found that was something they wanted to do. Now they're going to have the extra consideration that, okay, if they do that route, they're going to end up paying a pretty big fine. And there's really no way around it. But that's really the only situation that it's affecting people, because most people get probation. And when you get probation, it's not considered a final conviction. The conviction is probated. It's another one of those legal fictions. But bottom line is most people don't get assessed that fine. Now, courts might end up interpreting it differently. I'm not sure that's how the legislature intended the law to read, and they might go in and change the wording. But for now, it doesn't seem like you have to worry about those fines unless you take a jail sentence. So let's talk about how DWI affects your criminal history. A lot of people think a criminal history is a lot like a credit report, that after 7 years or 10 years, it falls off, but that's not true. Conviction is going to be on your record until the end of time or until they change the law. So the way you can either seal, there's two ways you can get it off your record. One is to seal it, and that doesn't actually remove it from your record. It hides it from public view. Law enforcement can still see it. Certain employers can still see it. if you're getting a license for a gun or something like that, it'll still be able to be viewed. Or an expungement. An expungement is way better because everything gets destroyed. It's like the record literally never exists. It never existed. So it's much better. Criminal history consists of 3 parts. One is going to be the arrest itself. The second is the disposition of the case, and the third is any jail time. So another misconception people have is if the case gets straight up dismissed, they think that it's not on the record. But because it consists of 3 parts, the arrest itself and the jail time you spent, if you spent 1 night in jail, those are still going to be on the record, and you have to go with a process and get it expunged. And the good thing about Texas Legal is Texas Legal does cover the expungement as well. You do still have to pay court costs with that. It's usually about $450, and the process takes about a year. Can be less, but just on the safe side, it takes about a year. So on which outcomes can you get expungement? Dismissal, Class C refile, pretrial diversion. You can get an expunction on all of those, with the caveat on that pretrial diversion, unless you waive that right with the prosecutor. With an obstructing refile, it's unclear. So there's a new case that came down literally about a month ago that seems to suggest that you can get an expunction with an obstructing refile. But if that's something that's very important that you get the expunction, you can't count on that. That will have to be determined by courts in the next year or so, year or two. We'll have some clarity on that. Convictions cannot be expunged. So if you take a Class B or Class A conviction, that's going to be on your criminal record. If you do a deferred adjudication, you can get it sealed, but not expunged. So those are kind of the different ways that you can handle the criminal history aspect of it. So it's very important to go over with your attorney what your different options are, because that can, it can have long-lasting impact, right? So criminal history, especially for someone who's a young person, has you don't ever know when that conviction is going to come back to bite you, whether it's going to be applying for a job or whatever. So if you can keep that off your record with an expunction, it's very important. It's very important to understand like the way you're handling the case and what those ramifications are going to be for your record. So that's one to really pay when you are talking to your attorney, is to just pay close attention to those differences. Now, we talked a little bit about the driver's license. So I'll just mention real quickly occupational licensing. So even if you request that ALR hearing, 9 times out of 10, you're still going to end up facing a license suspension. It'll just happen after the hearing. So once you have that hearing and your license is suspended, you can keep driving with something called an occupational license. So you do have to petition the court. Again, I believe this is something that Texas Legal would cover, but you would, again, have to pay certain court costs. There are also other requirements. You have to get an SR-22, which is basically from your insurance company, and sometimes up your insurance rates. You have to, excuse me. You also need to, see, where were we? Oh, you also need to get your driving record and just, there's a list of steps that you have to do. But the bottom line is you can keep driving. It's technically for essential needs, but the way the occupational licenses are written these days, you can pretty much drive anywhere in the state of Texas. So if you are driving out of Texas, it can cause some issues, but other than that, it's not a big deal. Anybody? I think that's kind of wrapping it up. I could talk another hour, but I don't want to get too much in the weeds here. But if there are questions, is it possible to view it in its entirety? That's a Megan question. I'm not sure. I think so, though. But I think kind of the key takeaways here is, a DWI is going to definitely be a hassle. It'll be a pain, but at the end of the day, it's not going to, you can handle it in ways that doesn't interfere with your life too much. I think typically the thing that interferes the most is going to be a condition like that ignition interlock, and if you can't handle that, that's when it can kind of escalate, and then you have to have additional conditions and everything like that. But it's not going to ruin your life. It's just going to be a pain for a little while, and you handle it, and then it's something that you don't really have to necessarily think about. But if there are no other questions, I think that's all I have. I hope that was helpful for everybody. If you do have more questions, you can always give me a call. Typical timeline, yeah. So pre-COVID, I'll say pre-COVID because it does seem like we are going back to that. So if I have a client that wants to rush it and get things going quickly, I do have a client like that at the moment, actually, and we're trying to get the process going. We can complete it 4 to 6 months. I know that sounds like a long time, but in legal terms, that's actually really quick. The typical case is going to last a year, maybe 9 to 11 months, but it can definitely go up to 15 months. I have one case that just resolved that was from 2018. Now he hired me a little bit late in the process, but still, it can definitely go that long. The thing that I do tell my clients is, I know it's a lot of times you're anxious to get it over with, and I totally sympathize with that. And I think I'm anxious to complete it as fast as I can too. But a lot of times your outcome is going to improve the longer you wait. The prosecutor is just going to come down on, usually once they give an offer. I know occasionally you get that prosecutor who's like, oh, I'm revoking this offer at a certain time, but usually that offer is like a standing offer. They want to resolve these cases. And so they're not gonna, even if they say they're gonna revoke an offer, they don't revoke an offer. The offers only go better. They only get in one direction. So by waiting, you can actually get a better outcome in your case. But at the same time, nobody wants to have an open criminal case. So I do understand the desire to speed it up. So usually I listen to my client. I ask, I tell them, what's more important to you? Get this case taken care of now, or do we want to try and push it a little later and see what we can get from the prosecutor? And 9 times out of 10, that offer does improve. So, but I guess just in a general term, between 9 to 15 months would be a general timeline from arrest to disposition. I think that's all I got. Thank you everybody for coming. I do appreciate Texas Legal for having me, and I appreciate everybody who's there watching. Like I said, if you do have any more questions, even if you're not in Travis County and you're watching this and you have a DWI and you have some questions, give me a call. We'll set up a consultation, no charge or anything like that. And I'm happy to spend some time talking to you. I think that's it.